Welcome to the Office of Planning and Development's monthly webinar series. Today's webinar is entitled An Introduction for Planners to the Registry of Deeds and Surveying in New Hampshire. I know it's a bit of a long title, but I wanted to make sure that all that information is in there. The purpose of today's session is to provide a better understanding of sort of three very important roles in the planning process and actors who sometimes go underappreciated. That is the surveyors, the experts that are often representing the applicants or abutters, and the Registry of Deeds, who ultimately, accept and record plans or plats to make them official. And obviously the municipal boards play a role there too. So we have these three sort of actors that are moving, and some folks know a lot about the registry. I know that a lot of people don't really know about them until you go through, until you try to record something yourself, and then you realize sort of there's this whole system there that until then is an unknown. So I hope that folks come out of this with a little bit better understanding of the roles and responsibilities of the registry, the surveyors, how they all work together in the municipal planning approval process. Quick agenda here. We're doing our introductions now. We're going to have a short introduction of the registries by Kelly. Mark's going to take over with an introduction to the surveyors. Steve's going to provide a commentary from the municipal perspective, and then the panelists will discuss some questions, common questions, for about 15 minutes, and then we're going to end with Q&A if there's time. We're going to try to respect everybody's time and get out of here at 1, understanding this is a lunchtime webinar. This webinar will be recorded and posted to the Office of Planning and Development's YouTube page, so folks who aren't able to make it today can watch it after the fact. So that said, I'm going to let the panelists introduce themselves. I guess I'll quickly begin. My name's Michael Klass. I'm a principal planner with the Office of Planning and Development. We're in the Department of Business and Economic Affairs. With that, I'm going to kick it to Kelly first. Why don't you tell us a quick thing about yourself?
I'm the Grafton County Register of Deeds. I'm in my 6th term. Before that was vice president, before that secretary, and I was one of the ones that traveled quite a bit to national conferences over the last 10 years. That goal being to stay ahead of emerging issues, and we all share a passion for the job, and the public record pretty much is what drives us. And I'll hand it over to Steve now.
Good afternoon, Steve Buckley, Legal Services Council, Municipal Association. My job is to provide legal advice to our members. But before I did this job, started it in 2014, I practiced primarily representing municipalities. And so doing that, spent a lot of time working with planning boards and zoning boards of adjustment. I'm currently on my zoning board of adjustment in my town of Bow and was on the planning board for about 12 years. So I have some familiarity of how this recording of decisions by planning boards is an important part of the land use system here in New Hampshire.
Thanks, Steve.
I'm getting it over to Mark. Sorry.
I'm just going to interrupt real quick. Steve, I think that there's a slight buzz on your computer when you were speaking, so we'll monitor that, but just as an FYI, it wasn't overwhelming, but I think that it's coming from your machine. So
yeah, I had a problem with my headset. I don't know what happened, so I had to turn it off, but it's still buzzing in the background. Sorry.
Okay. Yeah, no problem. I just wanted to make sure that we could figure it out. All right. Sorry, Mark, your turn.
Oh, no problem. Thanks so much. My name is Mark Condedematraki, and I'm from GC Engineering. I am a licensed professional land surveyor and a licensed professional engineer. And our company has been in business since 1996. This is our 25th year in business. And we're very happy to be here presenting and helping to answer any questions and provide clarity for the group.
Great, and I do thank you all. I know that sometimes I think people think that this time of the year is not a busy season, but at the very least it's hectic. It seems like it's busy for most people. So I know that you're carving time out of your days for this volunteer webinar, and I very much appreciate it. So that said, we are going to move on to Kelly's presentation. Kelly, all right.
All right.
Looks like you're driving. So
okay, got the wheels here.
Perfect,
so this is a PowerPoint that I did a couple years ago for one of your annual conferences, and I've adjusted a little bit. One of those group affiliates that I go to is Property Records Industry Association, PRIA. And what it does is it brings the lenders, the elected officials, technology, and title together. And it's a tense 2-3 days to talk about those emerging issues. So this was something that one of the board members that happens to be our software, he did it a little bit. I added New Hampshire specific. Wait, I'm going to go back. So it begins with the official public record. The recording of important documents is one of the oldest functions performed by government. Back to Rome, it was so-called the Law of the 12 Tablets that talked about legal procedure, debt foreclosure, paternal authority over children, and property rights. So this type of recordation of ownership has been around for a while. And with our country, the moment, I love this quote of John Adams, the moment that the idea is admitted into society that property is not as sacred as the law of God, and that there's not a force of law and public justice to protect it, then anarchy and tyranny commence. And property must be secured or liberty cannot exist. On a national scale, we get into a lot of situations with South America and Indonesia, and Libya is a personal favorite of mine to look at, how you can truly destroy a country by destroying who owns what. It's a quick way to go. And the founders of our great state of New Hampshire agreed. So much so that our office is included in our Constitution. And it's right there. County treasurers, registers of probate, county attorneys, sheriffs, and registers of deeds shall be elected by the inhabitants. So that's where we stand. And that is part of one of the hats that we must wear, is to run for re-election every 2 years. So we've got to have a commitment and a passion to this that includes that. And there are other roles. These are our duties as set forth by the New Hampshire law. Section 478 is pretty much dedicated solely to the registers of deeds. And I will summarize here, protection of the record. It's the main thing. Before I retire, I will be updating this for modern threats. There's no mention of cybersecurity, electronics, everything that's going on, all those emerging issues that I mentioned from the national conferences. We are the gatekeepers, and we want business to conduct. We want to record documents, but we are the gatekeepers, and we do wear many hats. I just did a job description actually a couple weeks ago. CEO, CFO, CSO, CIO, and archival specialist. So we wear a lot of hats, but we are bound to this duty. I do spar with my commissioners and delegation over the obligation to raise revenue, because we are considered the cash cows, but that's something that the state of New Hampshire placed upon this office. The true role is the database, the foundation of who owns what. And we're all very passionate about that. Plat law, this was written, a little blurb by Catherine Barabee of Stratford County. She's our vice president right now of our New Hampshire Registered of Deeds Association. For this webinar, this is very applicable because we've been talking about more and more documents wanting to be recorded at the registry that do not follow this simple statute. Map of specific land area whose boundaries are defined by metes and bounds. So that's something maybe that will come out of some of these conversations we're going to have in the future with the Surveyors Association on how to tighten up some gray areas in our current legislation on that. But we'll get into that in question and answer and how we take what we learned today and move forward. I'm going to just broad picture, big brush this. This book is great for nerds like me that's so passionate about our system. Mystery of Capital, Why Capitalism Triumphs in the West and Fails Elsewhere. It's a great book on the big picture. This is also a fantastic read for people who want to dive deep into our country. The Not So Wild Wild West, Property Rights on the Frontier. And this cannot be more timely, I think, with what New Hampshire Housing just said about affordable housing. It talks about how Hollywood exploited the story for Hollywood, and that really our country developed in a cooperative manner. We had to share the same roads. We had to build things together. share water. So it's a great read, again, for the basics, where we started, the not so wild, wild west, by Terry Anderson and Peter Hill. But Mr. Capital, great also. So the public record. With an official public record, property title can be determined with confidence. Real estate transactions become commonplace. Utility companies can safely provide service. Property maintenance and enhancement occurs willingly. Financial institutions accelerate the concept of property ownership. Property ownership can be leveraged into further needs, and that's a big one. Economic growth results over and over again. Without, as you say, it's not easy. Locking us in. You know, you can't verify what you own. How do you get a utility company to agree with you? And then you can go down the road of the finance with secured debt and unsecured debt and what interest rates look like without being able to prove what you own. As to registered deeds, we're tasked with the management and protection of the public record and the document it contains, especially, of course, relating to the ownership and transfer. Records that provide rights to someone other than the owner, liens, mechanic liens, partnerships. Services, the recording of new documents into the official public record, deeds, mortgages, et al. At the accessibility and searching of the records and documents that make up the public record. That has really come into focus in the last 5-10 years with the internet, and COVID definitely accelerated that through the charts. We were seeing e-recording companies come in, we're watching, we're easing into the e-recording, and COVID saw such a spike in the need to e-record that it actually broke the payment system, the third-party in-betweeners. It crashed it. I want to say it was after Memorial Day of last year, and we went through 2 weeks of bookkeeping nightmare, tracking, tracing money for documents. In the old days, you'd bring in a piece of paper, the money was correct, it was recorded, booked and paged, and it was an official document at that point. It's much more complicated now. And also automation. Our software vendor makes it easy for people to different aspects of looking at it, whether you're a title search company, whether you're a citizen that just wants a copy of your mom's deed. We would be quite more highly staffed right now if we didn't have the ability to have automation so someone can search our system, print a deed on their own computer, put in their credit card and pay for it. Without this automation and software, our budgets would be much bigger for staffing. Why are these services and the official public record important? Because the basic of the transaction, you get a motivated seller, a willing and able buyer, and confidence. It makes the official public record makes it possible for the buyer to determine the confidence in the seller's price. And my oldest son just bought a house last night, so I am out of my mind today that this basic function of our government will help secure my granddaughter's future, that he's bought a great place in Vermont. Without that confidence, few, if any, real estate transactions would take place, and in a much different way. Fundamentals of our office are integrity, accessibility, and security. And in our modern age, security is, I can't talk enough about that. Integrity in the way we do business, and in the way we treat people and each other, and in the accuracy of the information we gather into the public record, the official public record. A lot of that is out of our hands, as we, of course, have no authority over the content of certain documents. But when it comes to plat law, of course, we are examining that all the critical elements are there. Accessibility, making it easy to record proper documents. We want business to conduct. Making sure everyone has access to the public record so it effectively does its job, determines the property title confidence, and assuring that our systems work cooperatively with other courthouse systems to provide maximum efficiencies and enhance information integrity. And I'm going to go off script a minute here. It's a very little known fact that working together, the Register of Deeds and the Department of Revenue, we stream our certain segments of our data to Department of Revenue on a daily basis. That is the foundation of our equalization program. Without that free data stream, we'd be spending an awful lot more money and time and energy collecting that type of data. So working cooperatively to make our state run more efficiently should be one of our guiding principles. And we do work together. Just a minute here on accessibility and differences. We can get into it in questions, but we are a tight organization. We all bring very different pieces, skills. I appreciate that we all come from different backgrounds and different bases of knowledge, because a good association really taps into the strengths of everyone to make the overall organization much stronger. Security, protecting the public record for peril and corruption, that's a challenge. And protecting against misuse of the information contained, that is a challenge as well. And in summary, the official public record is critical to our country's continued success and existence. And as your County Recorder of Deeds office utilizes the state-of-the-art technology, critical and proven procedures, and continue to keep the public record accurate, accessible, and secure, as we've done for 250 years here in New Hampshire, and we're preparing for the next 250. I think that's all I've got. I do want to do one quick shout out to, how am I on time? To the staff. Generally, we've got some serious veterans for the offices that are at the counter. And they know what they're talking about. And they are dedicated public servants who really are as passionate about the job as we are. And that's it for me.
Thanks, Kelly.
Thanks.
So a question did come in as contour lines, but I think what I'm going to do is defer that to the panel discussion.
Sounds great.
Because that's kind of a consistent theme that I've heard, and so I think it'll be better there. So that said, Mark, you are up, sir.
Sounds great. Thank you so much. So I'm just going to briefly talk about surveying, the history of surveying in New Hampshire, how it ties into registries, and just some brief duties of the surveyor themselves. So in New Hampshire, surveying was adopted, licensure of surveying was adopted between 1968 and 1970, and it was by statute by the legislature. And the regulation is recorded in RSA 310A53, and that empowers the board of licensure and creates the surveying license. Prior to that, there was no licensure for surveying in New Hampshire. Essentially, anybody could be a surveyor, and anybody that could claim competency could go out and measure lines and bounds and angles. A lot of that work was done by civil engineers prior to the survey statute being adopted. And, different firms and different companies would essentially hold themselves out as surveyor, and there was no real regulation or standard or requirement of what needed to be done or shown. And so that's why the legislature stepped in and they created the surveying statute and the regulations and minimum standards that govern surveyors. Now, the practice of land surveying is defined as any service or work, adequate performance of which involves the application of special knowledge of the principles of mathematics, related physical and applied sciences, and relevant requirement of law for adequate evidence of the act of measuring, locating lines, angles, elevations, natural and man-made features in the air, on the surface of the earth, within underground workings, on the beds of bodies of water, for the purpose of determining areas and volumes, for the monumenting of property boundaries, and for the platting and laying out of lands and subdivisions of land, including the topography, alignment, and grades of streets, and for the preparation and perpetuation of maps, record plats, field note records, and property descriptions that represent these surveys. So there's a whole lot that's included in that, and to unpack it all would take us quite a bit of time. But just briefly, there are different types of surveys and different functions that surveyors perform. There's construction survey, there's site plan survey, there's traditional boundary survey, there's flood survey, there's hydrographic survey. So there's many, many different aspects and disciplines that surveyors can work in and perform. Now, again, prior to that adoption by the legislature of that law, there really was no any kind of regulation governing surveying, and so surveying, kind of tongue-in-cheek, has always had the nickname of being the second oldest profession known to man. And surveying has been around since obviously the pyramids. There's evidence that the pyramids were laid out by surveyors, and the way that the pyramids are oriented, as well as their vertical ascension. So there's history and there's records of surveying going back thousands and thousands of years. We have to understand too that as Kelly briefly pointed out, that there is a plat law that exists in New Hampshire, and that plat law is RSA 478(1)A. And that plat law essentially lists and governs what must be shown on a plat. And then there's also different details as far as font sizes, shading, etc. Now, when we say plat law and people talk about a plat, it can get confusing because a plat is different from a plan. And we have to understand that there's a distinction between the two. So essentially a plat is, and it can be, a two-dimensional rendering of an area, a boundary area, an area of land referenced to some other monumentation. And a plan can be another graphical representation that may show some kind of proposed or design condition. So there's really a difference between a plat and a plan. And that's why there's a distinction and why it's called the plat law and not the plan law, obviously. Now, the job of the surveyor, and we have to keep in mind that the statute detailed and defined what surveying is, and that surveyors will measure and essentially record boundaries. But we have to understand too that boundary law itself is rooted in the courts, and that surveying is really an opinion-based profession. The job of the surveyor is to research and then provide, an opinion of where and what those boundary lines are and should look like. And then if there's a dispute in those lines where maybe multiple abutters or parties do not agree in where those lines are that the surveyor has laid out, then ultimately a judge would decide and decree where that boundary is specifically. So, a surveyor's job is really to render an opinion of where they believe, based on, knowledge and calculation, that those boundaries and monumentation are and should be. Now, we have to keep in mind that the registry is a repository. It's a repository for records. And there's a wonderful, wonderful wealth of records in the registry. But we have to also keep in mind that in surveying, there is also a significant amount of records that are outside of the registry. There are many, many unrecorded plats and plans that are out there that are referenced in title and deeds that are recorded in the Registry of Deeds. So, not everything gets recorded when it comes to plans and plats. And, that's certainly something that, can impact title and other aspects of it. The role of the surveyor in conjunction with the registry is very important as far as collecting the information and the data, and then providing it to the registry, where that data is then, stored and memorialized for, as Kelly said, the next 250 years potentially. And, it's important that those records are, kept and memorialized because, again, a deed is not, it shows what your title is as far as, what your potential ownership of property is. So, And I'm not an attorney, so I'm not going to start getting into what title is and how title is affected and whatnot. But, you know, essentially by putting that information on public record, it lets everybody know what everyone's intention is. And, you know, that's why it's very important that a lot of the survey plats and boundary surveys are, you know, recorded in the registry, so that not only is that information out there for all to see, but also so it's referenceable, so that in the future that information can then be referenced and gone back to if there's ever a question, you know, or a dispute, or, you know, some other information. So, you know, that's kind of the long and short of surveying, and I think I've run through my time for the most part. So I'll look forward to questions, you know, in the panel.
Great. Thanks, Mark. I appreciate the plat versus plan distinction. I think that's always I don't think everybody really understands that. Mr. Buckley, it's your turn.
Thank you, Mike and Mark. I guess the key thing that I want to convey from the municipal perspective is to ensure all the conditions of approval and the details contained in the decision-making by a land use board get recorded at the Registry of Deeds. That is paramount. So the planning board or the zoning board of adjustment principally, but it could be other land use boards, when they make a decision, and they've spent a lot of time at public hearings hammering out what the conditions of approval would be, we want to make sure that they all appear at the Registry of Deeds. Now, I know there was, to some degree, a change in the statutes back in 2004, 2005 with regards to recording of site plans. I'm not going to get into the issues surrounding that, but I would say this: what's important for a planning board, especially, their job is to approve subdivisions and site plans. When you approve where the building is going to be located on the site plan, you want to have a record of that being the case. And it is very helpful to make sure that that record is recorded at the Registry of Deeds. Certainly with regards to subdivisions, the divisions of land, the location of new roads and utilities, that all is going to appear on the approved subdivision plan and is recorded at the Registry of Deeds. Now, there's really kind of two essential ways that these other matters that contain the conditions of approval appear at the registry. They could be as notes on the plan, or they could be in a separate document called a notice of decision. I think the better practice, if as much as possible, if you're on a municipal land use board or you're someone who assists a municipal land use board, is as part of a subdivision plan approval, have a separate notice of decision that's tied into that subdivision plan. So when you record the subdivision plan, you get the plan number, and then you record a separate document in the exact chain of immediately after the recording of the plan. Here is a notice of decision laying out all the details of the planning board's decision, and you tie that in by putting the plan number on the notice of decision document. That's ways you can be sure that at the record title, if someone has a question of what were the conditions of approval, they're right there in front of you, recorded in the chain of title right after the subdivision plan is recorded. Now, I personally have had a number of cases where I represented municipalities dealing with enforcement of conditions of approval with regards to site plans. And the practice today is site plans are kept at town hall. And if someone wants to verify what were the details of the approved site plan, where the building was located, where the lighting is supposed to be, where the parking is supposed to be, whatever the case may be with regards to that approved site plan, you have to go to town hall to look at the approved site plan. I would like to see at some point where site plans could in some fashion be recorded so that there is no question that those are the conditions of approval that the planning board assigned, not just the written conditions, but also such things as where's the parking supposed to be, where's the lighting supposed to be, where's the landscaping supposed to be, so that if you have a question with regards to enforcement, there's no doubt that that was the condition of approval. If I'm a subsequent owner, I was on record notice that that was the requirement of this particular approval by the planning board. I unfortunately have found, and this happens unfortunately all too often, where towns can lose documents, they can lose plans, they can lose minutes of planning boards. I know of towns that have
as many as 10 years worth of planning board minutes which have been lost. The beauty of the registry is it's always there. It's recorded permanently. So that's the other reason why, as much as possible, I would like to see these conditions of approval and, if possible, site plans be at the registry. We know they're always there, so we can always check the record title if there are issues with regards to what the planning board did 10 years ago, or if someone's a subsequent buyer, they know they're buying into certain things that they have to comply with as imposed by the planning board. But this also applies to zoning boards of adjustment. I think it's a good idea when the zoning board of adjustment makes a decision and says this is a variance or special exception that we're granting, that is also recorded at the Registry of Deeds. So again, any conditions attached to that notice of decision show up in the record title. These are just, I think, generally good practices with regards to ensuring that it is well known by any bona fide purchaser for value. These are the things that touch and concern this property and are things that the town will expect compliance with if there are issues with regards to subsequent uses of the property, and is the current user of the property in compliance with the terms and conditions of approval. Planning boards, ZBAs especially, spend a lot of time doing all this work, and it's, I think, important to know that there's a permanent record title of the decisions that our land use boards make. All set, Mike.
Thank you, Steve.
If I may interject real quick.
No, you're not interrupting, because I'm going to kick it to you. I think that maybe this can be the panel conversation. I mean, the site plan recording has come up a lot. So what are your thoughts on that, Kelly?
Let me just say, I bought in the unzoned town of the Wild West town of Orford 24 years ago and joined that planning board, and talk about PhD and education right there. Yes. Absolutely. And it's so funny with these smaller municipalities, it's the costs. The cost trickled back to the landowner or proposed landowner, $16 for that notice of decision if you get it in one page. $16 with that valuable information in there to get recorded. So sometimes it's the, short-term goal doesn't serve the long-term goal. So $16 for one page to do that. And just as you said, to note the plan number on that. So it's all about cross-referencing. Why we don't like a lot on plat or plans is because our main goal, it should be all of our main goal, is that it's readable in whatever format we're stuck with in 20, 50, 100 years, that you can read it and decipher it. So very busy plans, to go to microfilm is tough, and we need to preserve this stuff forever. So that's why we like to keep topo off. Or I had actually, just real quick, a couple years ago, 2 engineers and an architect up here. It was a big closing, and they had 4 colors on 8 sheets of paper. I'm like, it's not going on. It's all going to be grayscale. You're not going to be able to pull it back. So, and actually one of the other registers said she rejected the other day over something like that. And they said, you're killing my creativity. Like, stop.
So Kelly, you bring up a point that there's a couple questions in the queue that relate to line details, yes. And contours and topos and hatching or cross hatching. I mean, I guess, do you have any guidance for the planners out there as far as, you say not too much, but how does one figure that out?
I know. And that's, I think, where we come together as a group, going forward to see if we want to revise some legislative language on our gray areas. It's getting more complicated, and we are certainly developing. It's time to act sort of now, going into the next year or two cycle. Identify what we want to improve on and work together to get it done.
But right now, is the amount of line detail governed by statute, or is that just a call that is made at each registry? It
is in statute, but what we're seeing is the towns want more and more recorded here that they should really be responsible for. We brought this conversation up because it blew up with one surveyor with us all, and he called around asking. And I said, well, for instance, in Orford, we're dealing with our sand pit. Topo would be very helpful on that. It's how deep the sand pit's going to be for the town. So we understand, you're trying to convey a lot of information. on that Mylar, but it's the readability of the critical information on our end. So I think it's something we all need to talk about and work together as we, clean up some gray areas. But we should, let me mention the one issue we had, I want to say 6 or 7 years ago. It was the Merrimack Register, a veteran, Kathy Gay. All the cell tower companies wanted to dump their records here. And Kathy held the line with, there's no meets and bounds on that. We're not doing your bookkeeping. So that's what sometimes we feel, that do a separate sheet, if you need to put all that on, but for the plat, keep it as clean as you can for us, just for the future. I just ordered up and got approved a $175,000 microfilm revision project. I'm doing everything from day one, brand new, because it's an archival medium. And to be able to decipher what's on these old plans in a clear, crisp manner. Who knows what technology we'll have in 10 years, but it's all got to transfer.
Yeah.
Let me just add one other supplemental issue, which I didn't really touch on, but it's an important one for municipalities, especially with regards to subdivisions and site plans, but subdivisions in particular. Many subdivisions have on them indicated a detention basin, retainage areas, easements for drainage, et cetera. And all too often, it's not clear what are the terms and conditions of these various easements. So I just would urge planning boards, and again, you can minimize the amount of detail that's on the plan, but at least locate these easements and where they're indicated on the plan, but then have a separate easement instrument recorded at the registry. This is a drainage easement. Who can have access? This is a detention basin. Who can have access? This is a conservation easement, and have a separate easement instrument so that the terms and conditions of that easement as conveyed by the developer to the town are well set out. And again, that serves a very important purpose long run in terms of managing, especially municipal highway systems, when you have a recorded drainage easement.
Well, look at what Northern Pass went through, with patching all those easements together.
And I think, to just segue off of what Kelly said, this is part of a larger conversation about record retention and what should be recorded and how. And, in the surveying community, obviously, technologies have changed, and no one is drafting plans or plats by hand anymore. No one is using wet ink. Everything is done electronically and digitally through either some kind of AutoCAD or Carlson or electronic computer-aided design program. And as a result, when the plans or the plats are printed, they're usually printed to a portable document format, and those formats are crystal clear. And the only time where you end up getting the distortions in, the legibility is typically when you print it to paper and then scan it in for the recording process. And that's where you have issues with line weights and colors and legibility of font size. The minimum font size is an 8 font size right now. And it's a very, very good reason for that, because you can't see it or distinguish it if it's scanned in. So this is a really good beginning and conversation to start talking about, the electronic registration of plans and plats and the retention of that information, where, we're not printing out paper and then, submitting it to the registry, where we're providing, a crystal clear, electronic format. And, there's obviously lots of issues that go along with that. And there's lots of, questions and information. It's not something that can just magically happen. But, there's certainly a road to that someday. And, certainly collaboratively, I think we can get there. And that would in itself help to assuage a lot of the problems with legibility and, line shading and line weights and stuff like that. So.
Interesting. Thanks. We had a question come up that's slightly different, but it's or off this topic, but it's one that I've heard a lot, and that's who records the approved plans. Is there some consensus on the applicant or the town? I see. Let me finish the question, then you guys can jump in, because clearly this is an important one. So the sub questions are the more important ones here. What's the follow-up protocols if a registry rejects that recording? Who's notified? So now I will, you all three reacted. So why don't we start with Steve, because he's.
The town records the instruments. Do not let the applicant do it.
Ever.
You record. I can't tell you how many times I find out after the fact, especially with regards to Class 6 and private roads. Towns can allow people to build on Class 6 and private roads, but you have to record a limitation of liability for the municipal benefit under RSA 674-41. And I've heard many times the select board says, oh yeah, we just gave it to the applicant to record. And it never gets recorded.
It
So
drives me crazy when an applicant comes.
the
Well,
town,
the potential alteration
oh,
as well.
don't get me started. So
Don't need
the
to.
town does the recording. No ifs, ands, or buts.
What's really funny is when you pay a fee to the town for recording, and then they give you the plan or plat back and say, okay, go record it. That's really interesting. And, you know, we've seen that happen before, because now you've paid that recording fee to the town and they're telling you, okay, now you take it and go pay the fee to the registry and record it. So it's kind of counterintuitive there.
So there seems to be a consensus on who records. Now what happens if an approved plan is rejected? What's the process there? Maybe Mark, have you experienced that?
So I personally haven't experienced that. I've heard horror stories, you know, from other surveyors that have, and you know, you can talk about a range of emotions and issues it causes. In some cases, the surveyor has to revise the plat, and then it has to go back to the planning board for approval because it's now changed. You know, in other cases, it's been a simple, you know, change where it's just a line shading issue or a typographical error, and the planning board can still, there has been no substantive change to that, you know, approved plat or plan. And so the planning board can still, you know, sign off on it, and you can just revise it and record. But, you know, there's a wide variety of implications of having a plan rejected, and you know, the turmoil it can cause. So.
Well, I saw it a couple of years ago where a municipality, a developer was required to go get an adjoining planning board's permission under a statute that deals with subdivisions on boundaries of municipal boundaries. It's RSA 674:54, I'm pretty sure. And really, it was a request telling the developer all of his project was entirely in Town B. Nothing was in Town A. There was no Town A relationship to the project, but the registry said, no, because you're on a municipal boundary, not crossing it, you have to go to the planning board in Town A to get their approval, which was really unnecessary. And unfortunately, we actually had to get the county attorney involved. They were just backing up the registry of deeds, and the developer had to go to that other planning board who really had no reason, couldn't understand why they suddenly had to give an approval. But it was taken care of and eventually got recorded. It just delayed it by a couple of months. So that occasionally happens, and you end up having to really make sure you do what the registrar requires before it can get recorded.
And that pre-COVID, a few of the registries, our surveyors for the most part have their act together in our planning boards, but geez, I just lost my entire train of thought about that. The rejection at the counter, it's not fun for anybody.
And maybe Kelly, you were going to the pre-approval or the.
Oh, the pre-approval, yes. And then COVID sort of stopped that. We couldn't see humans anymore. That pre-approval is a great thing, especially for something that's a complex project.
So is that happening these days, or
we're going to discuss it going forward? You know, we're in uncharted territory now. You know, we just went to a mask mandate again yesterday.
Okay. And the comment or the question on who records gave a little follow-up and said that in his experience, the rejection letter from the registry went to the applicant, not the town. So the town wasn't aware of anything until a surveyor came back to him with an amendment. So there was some miscommunication there between the three parties. And I guess, you know, one takeaway here is to try to facilitate the communication so that stuff like that doesn't happen. All right. I have a question for Kelly. This is not in the question queue. This is sort of a talking point. Is maybe you can, and I know this is a big question, but maybe you can explain for folks why the registries are different, or why the practices are a little bit different at different registries.
Well, we inherit situations. You know, it's a long running office. We had one in Grafton, a registrar was in office for 25 years. So we inherit decisions. We also have the good fortune of being elected officials who then look to our Board of Commissioners for infrastructure decisions that must be approved, budget conditions, same with the delegation. They control the purse strings on how much space we have and truly who we go with as software vendor. We have to plead our case. So it's not, we may be constitutional officers, but all the decisions aren't left to us. You know, the delegations are made up of our House of Representatives, and they are looking out for their taxpayer. And a lot of times they don't understand the big picture, this silent engine that helps our economy. You know, oh, the Register of Deeds, that dusty old office, you know, I don't know, I got my deed. But, you know, it really takes nerds like some of us to dig in and see what this really means. For instance, Stratford County is not retaining physical paper or Mylar plans anymore. She inherited that decision. I disagree with it. I'm lucky enough to have space. It may be the old laundry room of the nursing home, but it's environmentally controlled now, and I'm rich in space. So I'll keep a physical copy until I'm no longer here. But so decisions are made by Board of Commissioners, infrastructure decisions, and budgetary conditions. The personalities and experience that the registers bring to office vary as well. I am a born manager, so I like I said, utilizing everyone's expertise. And we do meet and we do bash heads occasionally with difference of opinion. And when the end of day, it's the register's decision. But we also have to work with our delegations on budgetary. And usually the last couple fights have all been about the software contracts. There's no way on earth a county IT should be responsible for something this vast and this complicated. So it requires some money for that support system. We got very lucky in New Hampshire with a family-owned business in the 80s when computerization started. And then when they saw the industry was getting out of control with more complexities in technology, they shopped this country for the very best they could sell to. And in my opinion, they did. And I've been able to persuade my commissioners over the years to request for a waiver on bid. So we stay stable. So the users in this state are stable. So everyone knows what to expect. And you're not throwing new systems around because it's not easy. It's not easy on the staff, the users, real estate and legal communities, and the lending communities to learn new systems. So we're different, but we strive for uniformity.
Sure. But I think that it's important to sort of appreciate some of the driving winds behind the registries. You know, when I show up at the registry desk with a plan and say I'd like this recorded, I don't really appreciate all that necessarily. So I think it's good for folks to hear that you know it is a county, you know, run enterprise, and so this varies. And personalities aside, it's a more complicated you know, it's a more complicated process than just here, take this and scan it in, you know, which I think a lot of, you know, lawyers and property owners, that's kind of how they think of it, I think.
Right. And it gets bigger. When I first took office in 2011, there were 2 bipartisan bills in DC to federalize the registries. Which community wanted that? I think, is it the banking community wanted that, maybe? So, you know, with Association of Counties, we're sort of strong. We no longer have a national affiliate. It was dissolved, absorbed internationally. That's some scary business on all your own houses. Who controls the e-recording companies and all that goes into the technology now? It's called the Great Acceleration, but it's the elected officials that are pumping the brakes on that, and it's a fight.
Interesting. Thanks. So we have about 10 minutes left. I've got a so if anybody has any other questions, put them into the chat. I have a question for Mark, and it has to do with people using plans that have been approved and recorded after the fact for sort of modifications. So Mark makes a plan that's recorded at the registry. Then Mike buys that property, doesn't hire Mark, you know, looks at that plan and goes into the board with, you know, I want to put a shed over here or you know, whatever. Do you have any thoughts on the copyright issues or just any other implications of that?
Well, so copyright only occurs if someone were to go to the registry, print that plan out, and then try and monetize it or sell it. So if you're a homeowner and you go to the registry and you print out a survey of your property, you know, that's a depiction of, you know, it's a depiction of your title graphically. You know, can you sketch on that and submit it to the town and go through a form of planning or zoning process, you know, by changing it with your own hand? You know, towns, I mean, I guess if you want to put up a shed or something or whatever, I mean, you know, towns are the ones that are really making that decision and accepting it. You know, from my perspective, I would not ever want to see anybody take a copy of my plan, a homeowner especially, and then do a hand sketch and then submit it to the town for either a building permit or some other purpose.
Yeah.
Because, you know, you don't know what's going to happen after the fact. So, you know, the towns, and we've seen greater excesses in that, where we've provided site plans for commercial customers, and then they've taken that site plan and then gone back to the planning board for minor approvals and changes, which they've hand sketched on there. So, you know, it's really the municipality is the gatekeeper in that, and they're the ones that should be, you know, looking and reviewing and kind of saying, ooh, you know, that falls outside of our site plan regulations that's published and, you know, stored on our website or in town, which, you know, lists the specific requirements that you must have to submit. So, you know, it's an issue. It's not a copyright infringement unless you sketch something on there and then try and sell it to somebody as something else. You know, again, it's still a copy of a survey of your property, and, you know, you can do with it what you want. It's when you submit it to the town that I think the municipality has to look at it and review and see if it's appropriate to accept for whatever that purpose is.
Mark, let me ask you a quick question. Does the statute that requires the planning board to give notice to anybody who has a professional seal on a plan that's submitted to the planning board, does that work? Do you get those notices, and do you deal with getting such a notice that a board is about to address a plan that has your professional seal on it?
Yeah, no, not when someone is doing the modification on their own. No, we never get those notifications. And typically we find out about them after the fact.
And I will say, you know, in my experience, different towns have different, accept different degrees of plans, you know, different. It sounds like the sort of consensus here is that best practice is obviously not to do that, but I suspect that it's happening. And I also suspect it's probably for the more minor projects, like you said, Mark. You know, I want to put a shed over here. I would suspect that some towns are, you know, likely to accept that from a homeowner who's just, you know, why do I need to get a full plan when all I want to do is put a deck out here, and clearly I got my setbacks covered. And so again, it might not be best practice, but it's probably happening out there more than you think.
Well, boards should know that, you know, the statute says very clearly, any plan submitted to the planning board, any plan that has the engineer, architect, or land surveyor, soil scientist seal on it has to result in notice to that professional. So that is an obligation, and so that should be a way in which the interests of the professional are reasonably protected.
Absolutely. And you know, part of my role, and I just got to exercise it for the first time in 11 years, is to go to court with an old plan that predated plat law. 3 years in the making over a stone wall, folks. You know, and it was a blueprint drawing that I had to escort to Grafton County Superior 3 weeks ago. So, you know, there's reason. You know, abutting issues, huge.
So we've got about 4 minutes left, according to my clock. And I guess I'd just like to give everybody an opportunity to, if you have any quick practice pointers, tips or advice for folks, just in line with what we're talking about today. I think, Steve, you've kind of gone through yours with the record your notice of decision, so I'll let you off the hook. But Kelly or Mark, do you have anything to add?
I would like every planning board new member to attend all the trainings they can with New Hampshire planners. You know, you step up in your town, you're putting your head right on the table, and, you know, dig in and learn. You know, there's plenty of information out here and plenty of people, you know, willing to help. But learn your own subdivision regulations. Be active and be engaged.
Mark?
I would recommend that, you know, if any, you know, municipal agent has questions about, you know, surveying statutes, ethical requirements and guidelines, to reach out to the New Hampshire Land Surveyors Association. You know, we've got a wonderful executive committee that, you know, has a vast knowledge of, you know, different aspects of surveying, like I touched upon, and we've got a great executive director that, you know, would be very helpful in either directing you to the appropriate person or potentially answering some of the questions. So, you know, keep the New Hampshire Land Surveyors Association in mind as a fantastic resource, you know, for municipalities to get clarification on some of these items.
And if I might just say in there, same with us, we have a website, nhdeeds.org, and those individual county websites are so full of educational material.
Thanks. And I will say, Kelly, in my experience, whenever I had questions about, you know, specific documents, I mean, you have your recording standards online, but I always found the registry, you know, picking up the phone with your registrar really helps. And I imagine if you're on the municipal side, to sort of have a good relationship and an open communication with, you know, if you're recording lots of plans, it makes sense to sort of know the nuances of your particular registry. One question came in. Steve, do you have that RSA off the top of your head that requires notification?
RSA 676:4 Roman 1 small letter D as in dog.
Thank you, sir. And it looks like we're about out of time. If anybody has anything else to add, I will let them do so now. Otherwise,
I saw a question on LCHIP, and they just announced yesterday their grant give for this year. So just Google LCHIP, and they've got a good website too.
Oh, thank you. I think the question was, and this is sort of an aside. Yeah, how much is
4.7 million this year? They just announced.
Oh, great.
And we did have to fight legislation last year. They wanted to add an additional $10, and I fought that tooth and nail. You know, you're closing on your house. It's one of your tightest weeks financially of your life, and adding another $10 onto that, I was against.
All right. Thank you very much to Mark, Kelly, and Steve. I appreciate your time. We're at 1 o'clock. Again, this will be recorded. And I'll just say that Mark's actually in another meeting right now. So thanks for squeezing us in. I do appreciate it. It was nice to have all your perspectives. We'll record this, put this online. Kelly's slides will be up on our website. Hopefully this kind of helps provide a lens of information that folks didn't quite know or appreciate before. And that said, I'm going to bid everyone adieu. Have a nice afternoon. Thank you very much.
Thank you, everyone.
Thank you.
Great day, everyone.